Welcome to the FloridaDefense.com podcast. With over 30 years of strong defense and over 30 years of even stronger results, with FloridaDefense.com, you'll never believe you can't win.
All right, welcome to the FloridaDefense.com podcast. We are speaking to Bauer, Kreider, and Perry. Mike Kinney, he's a Tampa murder defense attorney. Same with all the attorneys there at Bauer, Kreider, and Perry. Mike, how are you doing today?
I'm doing well. How are you doing?
Good. Well, we're in the series. Basically, we talked about violent crimes. We've talked about assault and battery. You mentioned a little bit on homicide in the last one. We're going to be talking more about homicide and murder in this one, correct?
That's right.
All right. So I'll turn it over to you.
Sure. So in the state of Florida, murder has a couple of different categories. There's the murder that probably a lot of us are kind of accustomed to, the thing that we've heard about, premeditated murder. That's first-degree murder. So in the state of Florida, when a human being is killed from a premeditated design to affect the death of that person, what that simply means is the thought and the intent to bring about somebody else's death and the forethought, the thinking about it ahead of time, that's a first-degree murder. The reason why that's so significant is because of the penalty that charge is punishable by. In the state of Florida, only first-degree murders are punishable by death, by capital punishment. There's a certain process that has to be gone through in order to get that penalty. Because of some cases that have come out in the past several years, the juries have to make certain findings, and the juries actually have to make certain recommendations that the courts are the final decision makers on what the penalty is. The jury has to make certain findings on whether certain actions would warrant the death penalty. The next category is a second-degree murder, and a second-degree murder is what is commonly called depraved heart murder or depraved mind murder, and that's something that comes up when a person ends up bringing about the death of another person, but they don't have the premeditated design to do that. It's simply one of those acts where it's the person hates the other person so much or wants to harm the other person so much, but they don't think about it. There isn't some pre-planning, and usually when you see that come up, it's usually what comes up when two people meet each other in a heated moment and get into a fight, and the other person ends up committing some significant injury or harm to the person that ends up killing the person. So it's significantly different. It's still punishable by life in prison, but a second-degree murder is not punishable by death. And the second-degree murder basically talks about a person who ends up doing an act that's imminently dangerous to another person, which shows that he's got a depraved mind and he's regardless of human life, without any premeditated design to affect that death of any in particular person. So the idea is that it just shows that this person hates this other individual so much that he doesn't really care. He just commits this act that brings about somebody's death. After that, you get into a category that is known as manslaughter. The manslaughter category is kind of anything else that a person is killed where you didn't plan to kill that person. That's really the layman's explanation of it.
Kind of like a car wreck or something like that.
Correct. You can get in a car accident. Obviously, you have to show that there was some culpability, some criminal culpability involved there. But a lot of times it's somebody being careless with a firearm. But the manslaughter definition is defined as the killing of a human being by the act, procurement, or culpable negligence of another without lawful justification, and in cases in which such killing shall not be excusable homicide or murder, according to the provisions of this chapter. Manslaughter is a second-degree felony punishable by a maximum of 15 years in jail. Now, manslaughter changes. If a death happens, that's considered a manslaughter, but a firearm is used, then that takes it out of the second-degree felony range and it's punishable by up to 30 years in prison. So it changes things a little bit. So that's the basic categories of homicide. There's all these other little categories that kind of change depending upon other aspects, but those are the basic categories. Then, as far as first-degree murder, there's a lot of ways you can get to first-degree murder without the prosecutor having to show that you had a premeditated design to bring somebody's death. That's obviously, that can be sometimes difficult. Human beings, it's really hard to know what's going on inside somebody's mind, especially because most people don't talk about what they're thinking when they're doing it. So it's one of those things you have to look at the actions. But in the state of Florida, there's a thing called the felony murder rule. And felony murder is a rule that says if you commit one of these listed felonies, and they're basically forcible felonies, if you commit one of these listed felonies and a person dies in the commission of this forcible felony, you are guilty of first-degree murder. And that's punishable by, just the way a premeditated murder is, it's punishable by the death penalty. So that comes up in the specific scenarios where a person commits a trafficking offense, for instance, trafficking in a controlled substance, an arson, a sexual battery, a robbery, a burglary, a kidnapping, escape, aggravated child abuse, aggravated abuse of an elderly person or disabled adult, aircraft piracy, unlawful throwing, placing, or discharging of a destructive device or bomb, carjacking, home invasion robbery, aggravated stalking, murder of another human being, resisting an officer with violence, aggravated fleeing or eluding with serious bodily injury or death, felony that is an act of terrorism or in furtherance of an act of terrorism, or which resulted in the unlawful distribution of a controlled substance, such as cocaine, opium, that ended up bringing about the death of the other individual. So all of those specific charges I just listed, if a death happens and the person involved in it is committing one of those acts and ends up causing the death of another individual, that could be charged as a first-degree murder, I should say, punishable by the death penalty. There's another category called second-degree felony murder. Second-degree felony murder is very unique. That comes up when a felony is being committed, just like the listed felonies that we were talking about, and a person dies, but the person who does the killing is not one of the people involved in the commission of the felony murder. So best example to come up with is 3 guys go in to rob a bank, and they go in to rob a bank, and during the commission of the bank robbery, the bank guard pulls out a firearm and ends up shooting one of the co-defendants of the bank robbery. In that instance, the two living co-defendants are guilty, if they go to trial and found guilty, are guilty of second-degree felony murder. They didn't do the shooting. They didn't bring about the death of anybody, but the idea behind it is that they engage in a clearly, imminently dangerous act to the life and liberty of other individuals, and they are going to be held responsible for the death of anyone involved.
Would another example be, Mike, that if somebody, say, hires a hitman or pays somebody to
No, that's a little bit different, because that person, if a person hires a hitman and a hitman does the killing, that means that the people engaged in the common plan brought about the death. So that would be a first degree.
Oh, okay.
That would basically be principle of first degree murder, is what that would be. But the reason why second degree murder comes up in these situations is because nobody involved did the actual killing. It came from an outside party, a party not involved in the commission of a felony. So, and I think the reason why that came up is because, this is a crime that's punishable by death, and perhaps the legislatures thought that, the death penalty is maybe not necessarily appropriate for when somebody else commits an act that ends up causing the death of one of these people involved in the case, especially when somebody has really no role in bringing about the death other than committing the felony.
You mentioned in the last podcast about the under 21 rule.
Yes.
That's kind of the same in this as well.
Yeah, you don't get the benefit for capital felonies. You don't get the benefit of a youthful offender designation. So anybody who commits a first-degree murder does not get that gift. And a youthful offender designation is you have to be sentenced as a youthful offender before your 21st birthday, and it caps whatever your sentence is at 6 years. And that could be 6 years of anything: 6 years of probation, 6 years of prison, a combination of probation and prison. But no, it's not that easy to avoid the maximum penalties involved in cases like this.
All right. Anything else, Mike?
Well, so we just talked a little bit about the categories of murder. There's a third degree of murder. And a third-degree murder only comes up when a death is brought about in the commission of a non-listed felony. That means, I went through a list, right? Any felony that isn't on that list does not qualify you for a first-degree murder. But if you committed some other felony, let's say it's a grand theft, for instance, which isn't on that list, and somebody dies in the commission of a grand theft, well, that is a third-degree felony murder. And that's considered a felony of the second degree, punishable by a maximum of 15 years in prison. We talk a little bit about what the penalties are. It's probably good to know a little bit about some defenses available in murder-type cases. Obviously, murder, one of the things they have to prove that somebody's been killed. But I think what's important for a defense attorney to know and be able to show is maybe the why and how these things happen. Because sometimes the why makes a big difference. In the state of Florida, there's a unique statute called excusable homicide. And excusable homicide has basically three categories. It says that a homicide is excusable when committed by accident and misfortune and doing any lawful act by lawful means with usual ordinary caution. So that could be anything. If you're just doing what you're supposed to be doing, driving your car, and someone ends up getting killed, but you're following the law and doing what you're supposed to do, then that would be excusable. There's another section of that. It says, or by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. So that's a unique scenario, which could, what I'd say some categories that may qualify as that is people getting into a fight. People getting into a fight, and then one person just ends up maybe getting the better of the other person who attacked him, who came after him. A lot of times, when somebody gets killed, law enforcement officer does an investigation to determine whether or not that death could have been prevented, and maybe they make a determination that this person ended up killing the other individual and illegally. There's a specific statute that says if this act was done in the heat of passion upon the sufficient provocation, then that could be considered, the jury has to find that, but that could be considered excusable homicide. Like, for instance, or upon sudden combat without any dangerous weapon being used and not done in a cruel and unusual manner. So those are three different ways that you can be found to have committed a murder, actually killed a person. That act is found to be excusable homicide. And then there's, of course, the justifiable use of deadly force, which we see coming up in a lot of cases ever since Florida had the Stand Your Ground amendment to the statutes. The justifiable use of deadly force statute specifically says that a person cannot be charged with a homicide if they were found to have been defending themselves. And that falls under the justifiable use of deadly force section. Justifiable use of deadly force says that you're allowed to defend yourself. You're allowed to use deadly force if you feel it is necessary to prevent imminent death to yourself or serious bodily harm to yourself or another. And then the Stand Your Ground is not all of the justifiable use of deadly force statute, but the Stand Your Ground statute specifically stands for the idea that before you use deadly force, you don't have to turn and run. It used to be a long time ago that you did. So, in situations where people are killed either through a gunshot or some weapon, and the person claims that he felt he had to do it because he didn't, he thought he was going to be attacked by the other individual, you find a lot of times the justifiable use of deadly force and the Stand Your Ground defense is raised. And that pretty much covers the substance of the homicide statutes.
You've been listening to the FloridaDefense.com podcast. We've been speaking to Bauer, Kreider, and Perry, Tampa murder defense attorneys. We've been speaking with Mike Kinney, and join us on our next podcast.
Thank you for listening to the FloridaDefense.com podcast. Our firm has over 130 years of combined legal defense experience. Strong defense, stronger results. Consultations are free. Visit FloridaDefense.com today.